Hello everybody. We're just going to let people join. We will start in probably about a minute, if that's okay. Nice to see you today. Please do feel free to leave your cameras on if you would like to leave your cameras on. We like to see people's faces and see people interacting, but equally, if you need to have them turned off, it's absolutely not a problem at all. Fully understand. We'll ask you to keep your mics muted while we're presenting, if that's okay. I will start while the room started settled down, so I'll kick off now if that's okay. So good afternoon to everybody and welcome to today's Care England webinar with our partners, Hempsons. Thank you for joining us for what is going to be a particularly timely and important discussion, influencing outcomes in social care. That's funding, commissioning, behaviour and provider leverage. This session is designed for social care providers and focuses on the practical realities of funding negotiations and the often difficult relationship between providers and commissioners. Across the adult social care sector, providers are having to negotiate unsustainable fee levels, as we know, complex procurement arrangements, contract pressures, and difficult local relationships, all at the same time while trying to deliver high quality care in accordance with our obligations. So today's session is really about understanding the system itself, recognising where providers do have influence and using the tools available in a structured and constructive way. That will include how to approach funding decisions with greater confidence, how to challenge unsustainable positions, how to manage disputes with commissioners without damaging long-term relationships, a really important point, and how provider decisions can influence wider systemic behaviour. So we are delighted to be joined by Sam Stone. He's a legal director at Hempsons, and Sam brings real-world experience in disputes, procurement challenges, contract negotiations, and commissioning issues. And he's going to offer a real practical view on how providers can better position themselves within the current funding landscape. So as usual, this session will be recorded. Please do use the chat function should you wish to ask any questions as we go, and we'll try to cover as many of those towards the end of the session in a Q&A session. I'll also drop my email into the chat, as I know some people would like me to ask questions on their behalf anonymously. So Sam is going to talk for between sort of 20 to 30 minutes and take you through his slides, and we'll send those out to you along with a copy of the recording within 48 hours of the event closing. When Sam has finished, I have a bit of feedback then. When Sam finishes, I'll facilitate a Q&A session to address any questions you have, at which point you're free to raise your hand and ask Sam questions directly if you so wish. So without further ado, I'm very pleased to hand over to Sam. Sam, you seem to have disappeared from my screen. Over to you.
Thank you, Richard. So just to check, can people see the slide deck?
We absolutely can, yes.
Brilliant. Right, so thank you all for joining, and it's good to see so many people here today. As Richard's introduced, work across the health and social care sector, work for providers and for commissioners. I am a contentious disputes lawyer, covering public procurement, judicial review, and a large part of my work is contract disputes. And so quite a bit of today, I'm going to be focusing on what is in contracts, what to watch out for, what might not be. I will also say, being a contentious lawyer, what I tend to see is where things haven't worked rather than the times where everything works perfectly smoothly and you don't need to get lawyers involved. But what that does mean is that I do see quite a lot of missed opportunities, and that hopefully is going to be something that I can draw out with you today. So just in terms of the commissioning landscape, I don't think any of this will come as a surprise to anybody, the key areas of focus from the commissioner side, but I'm just going to pick up on that second point around the loss of relationships. Again, everybody will have experienced it across different kinds of commissioners, local authorities, ICBs, but just to emphasise that redeveloping those relationships as best as possible is always going to be an important part of managing potentially quite fractious and challenging disputes around funding, but also something that I will say and it's always something that I say when I deal with the matter for the first time, it's worth trying to put together your pitch, your explanation of where you are coming from and the issues that are relevant to you, in the expectation that the person who is listening to you will not be familiar with the background, will not be familiar with your business, often will not be particularly familiar with this part of the sector, particularly as there's staff turnover, staff change. So that as a starting point, work on the assumption you need to provide more information rather than less. Assume as little as possible, and you're setting yourself up to explain things perhaps to colleagues who may not be as experienced as you are. In terms of the legal framework, I could have put money at the top of every single one of these slides, frankly, in terms of Commissioner priorities, priorities from your side as well. Again, not going to go into the circumstances we find ourselves in. I have put those in rough order of significance, though, from the Commissioner side. So starting with the contracts, then looking at how they go about getting contracts in place and identifying providers, then looking at contract management and decision making by commissioners, and then finally points around the stability of the care markets, viability, range of different providers, and so on. As I said at the start, I'm going to focus quite heavily in terms of the contracts, because so very often from the commissioner side of things, that is the first lens that they are going to put onto a provider asking for more money. It is going to be a case of, what does the contract actually say? So with new contracts, it's going to be a case of understanding the terms before you sign up. I know it sounds obvious. I really wish that it's not a conversation that I had to have, but this is probably the best negotiating opportunity that you are likely to have during the term of a contract. It is the point where the local authority, ICB, is dependent on you and wants to work with you and is looking to get something in place with you. Once you sign up, they are generally extremely difficult to get out of, change the terms of, except within the four walls of the contract. Something I'm going to talk about quite a lot today is going to be leverage, but fundamentally leverage always comes back to, if it is more expensive for the commissioner to not work with you, you've got that leverage. If it is cheaper or the same price for the commissioner to work with somebody else instead, not work with you, you are simply in that worse negotiating position. You might still have legal arguments, but they're never going to be as good as being needed by a commissioner. And when you're looking at a contract for the first time, considering whether to go ahead with it, you're potentially in that position where the commissioner needs you. And it's certainly worth just that stress testing. What happens if there are gaps? Try and get them filled at the start. Try and get your contracts developed so that they actually do deal with situations where things change, care needs change, you're potentially being asked to do something different, potentially being asked to do different models of care, different arrangements. The more you can nail down early on, the easier your conversations are going to be further down the line. And commonly, everyone will be used to the overarching agreement and then the individual placement, the individual care agreements. Making sure you've seen both of them and understanding what should be in those individual care agreements when they come through, and what is covered in the overarching agreement. Because if, and wouldn't be unusual to see an individual placement agreement that actually has all of the details of the package of care, the price, termination, load of other highly relevant clauses. If you don't know what's supposed to be in there, if you've not established that early doors, when you start getting them through and they're potentially deficient, missing key bits of information, you can find yourself with a gap. And a gap in terms of what the commissioner's expectations are, what you're expected to do. And just on that final point, it is high risk to be delivering without a contract. I'm sure you will have all heard somebody say that before. It just bears absolute repeating, because your leverage falls away at the point where you are already delivering care to somebody. From the commissioner's point of view, they have what they need. They have met a care need, and you are left within that position of not being entirely clear what the terms potentially are going to be. So trying to get it nailed down in advance. As I say, the start of the contract often going to be better than 2 years into the contract, 3 years into the contract, from the position of negotiating with your commissioner and what their expectations are. A lot of this is done by way of procurement processes. Put it at the start there. Well, just going to pick up on a point actually that's popped up in the chat in terms of not getting the contract until after the individual's been with you for some time. I know it happens. This is an area where I think a lot of providers can and should be looking to push an awful lot harder on your commissioners. If the proposal is you care for somebody, getting the contract through that actually tells you what the terms are going to be, gives you the information you need to work out what care you're being asked to provide, it can and should be something that you are pushing for very early doors. I appreciate that I can sit here and tell you do this and then it doesn't happen, but ultimately, and subject to your contract terms, if you're in a position of going, well, you would like us to admit this resident, but you're not giving us a contract saying what we need to do, when those circumstances, we're back to that point about leverage, it will be a lot easier for you to push and hold your ground before the person's admitted, and potentially just looking at how you can push back on commissioners and go, I'm sorry, but until we know what the terms are, we can't commit to this. Just coming back onto procurement processes there, put it at the start, what is being advertised is what the commissioner is intending to award, and negotiating, pushing back, saying it's just not viable, making decisions whether or not to participate. Quite often I see providers take part in the procurement, win, and then suddenly say, but we don't think the contract is viable. The difficulty there is potentially there are 2, 3, 4 people standing immediately behind you who have said that they will deliver the contract. So there is a real risk that if you participate in the procurement process, indicate that you're happy with the contract, get the contract, and then say that you're not actually happy, the commissioner is going to be in a better position than they might otherwise be to just turn around and say, well, we'll go to the next provider. And something as well that I will say in the context of procurement processes, you really do have to move quickly. If you've got problems with the design of the procurement, the way bids are going to be evaluated, just what the requirements are, if you don't raise them quickly, you're very likely to find yourself time barred. So limitation in procurement claims can be as short as 30 days from when you knew that there might be an issue. So procurement, you have to move fast, get advice early, be ready to go when you know there's a problem, not when you know what the outcome has been. Existing contracts, and I'm conscious that this is going to be a lot of people's focus today. You've got them, but nonetheless, getting to understand what is in place, always critical, both overarching agreement and then each of the individual agreements, because this is your negotiating structure to a pretty high degree. So key things, what are you actually commissioned to deliver? Is that what you are delivering? Is that what you're being asked to deliver? Or are you actually contracted to do something different? How long is this for? When is this going to come to an end effectively? How long are you tied in for? How do you terminate? Can you terminate individual packages of care or not? And I have seen some agreements where it's not all that easy to do. Do you have to terminate the overarching agreement as well? And what happens to people after contracts terminated if they can't be relocated quickly? And then just all of those points in terms of what are you actually delivering, and what does your resident, what does your service user need? Does the contract reflect all of that? Because there you're building both your plan B, what you do if you're not able to agree a fee increase, because you're looking at things like termination, you're looking at potentially saying, well, contract doesn't cover us to deliver this, so we're not going to. But also you're building those opportunities where you can say to your commissioner, the care needs have changed. We need an assessment. That assessment needs to take into account this, this, this. We need more money. We need cost increases to reflect the cost of care. But you're sitting there, as I say, with your plan B. Your plan B of ultimately going down the route of, if we're not paid sufficiently for this contract to be viable, we will not be delivering it in the future, if that is the position that you plan to take. And again, that final point about reviews that affect how care is delivered, going back to your contracts and actually understanding how that fits with your specification, how that fits with what you've agreed to do, and making sure you don't inadvertently end up delivering a service that isn't quite what you were originally contracted to deliver, because once you start delivering it for the original price, it starts becoming harder to argue that you've been doing it for 2 years, but now actually you think you'd like some more money because it's more than you originally agreed to. Identifying this stuff early and moving to challenge to the local authority if needs be quickly, just likely to avoid perception from the commissioner's side that it must be fine because you've been delivering it fine for some time. Price review clauses, some contracts do have them. They're always on their own specific interpretation. What your contract says will determine how your price review operates. Generally, commissioner only has to do what the contract provides for. This is why I said before, it's when you've got a new contract, you have potentially the strongest negotiating weight, because if you have committed to a contract that says, for example, you will have RPI increases only, the local authority commissioner's perspective is likely to be you took the risk that that might not be enough, but you chose to enter into the contract anyway. So start with your own contract, start with what those terms are. If you've got a price review, work on the assumption that potentially is going to be what you get, and potentially quite difficult to get around that. Some of them are subjective. Some are local authority acting reasonably will consider the cost of care and the availability of services in the local marketplace, for example. So has to act reasonably, but the contract will be specifying what it has to take into account there. It has to take into account the cost of care, and it has to take into account availability of services in the local marketplace. It doesn't necessarily have to take into account anything else. And this is why I say it's always back to the contract as a starting point. Understand what's relevant, because then you can look at that and you can go, those are the 2 areas I need to cover off. Those are the 2 areas that council cares about effectively when it's carrying out this review. So I'm going to frame my submissions to them on that basis and justify the increase that I need in line with that, because if I put it in on some other basis, not only might they just go, that's not relevant, but then when I say, oh, but actually it is relevant within the scope of the contract, I will have undermined my credibility in terms of pushing for that increase in the future, because I tried getting it on basis A, was told I couldn't have it on basis A, then raised basis B, and it just starts looking opportunistic at that stage. So, comment in the chat on Braganza duties. Complicated. I don't think I'm going to have time to go into it in any detail. I do recognise the point that's been made, though, that there might be some concerns for some commissioners about having case law out there. Essentially, Braganza duty is where one party to a contract has got a right that impacts on the other, depending on how it's exercised. It introduces effectively a duty to act rationally, in the same way as you might be familiar with Wensbury unreasonableness, acting rationally, and that includes taking into account relevant considerations. So it can be a fertile area for challenge where a bad decision has been taken, but it's worth bearing in mind, as with Wensbury reasonableness, you're often trying to get into territory where the decision is so unreasonable, no reasonable public body acting reasonably could have taken it, and that can be a very high bar. So area worth looking at in more detail if you've got a price review clause, or if you get a commitment from a commissioner to carry out a price review, how they need to do it, and what additional pressure you might be able to have there. But again, comes back to the terms of the contract, what they've said they'll do, what they're required to take into consideration, and then looking at it through that lens. And yeah, again, here, there's a range of things that commissioners can take into account in addition to the impact on you pricing, your costs. And just to note something else that's come up in the conversation in terms of cross-subsidisation, public bodies look very often at businesses as a whole. So if you've got a care home that's got privately funded residents, publicly funded residents, it is very common for local authority looking at viability to go, as a whole, this business is entirely viable. everybody will be familiar, I think, with those kinds of conversations happening. There are things that providers can potentially do to separate out bits of their service, starting to see a lot more corporate models in care delivery to perhaps hive off one section from another and mitigate against that cross-subsidisation. But just for these purposes, just pick up that penultimate bullet point. Just because one aspect, one service user, one aspect of a business may not be profit-making in its own right, doesn't necessarily mean that Commissioner only needs to look at viability through that narrow lens, as opposed to looking at the business as a whole. So practical steps if you're looking at a price review, and this all applies whether there's one expressly in your contract or whether you are simply pushing for one. The more detail you can provide, the stronger your argument is likely to be, and just the more that there is for a commissioner to need to work through, and the more scope for you to run arguments along the lines of fail to take into account all relevant considerations. If you provide a lot of relevant information and it's just ignored, then potentially you are opening the door to legal challenges there. Touch on the point I've just made. If a commissioner wants to look at the service as a whole, then cooperating as far as you're willing to do so, as far as you can share information. A commissioner that is telling you that they want information is more or less telling you, in order for them to make the decision that you are asking for, they need additional information from you. That's not me saying that you have to hand over everything, irrespective of what it is, sensitivity, confidentiality, but it's worth thinking you want the people on the other side of this to think that you are approaching this reasonably pragmatically and minded to maintain those effective working relationships, and they are telling you they need information to make a decision. So in that light, it always is worth considering and seeing what can you do, what information can you provide, and even if it's not everything, what might you be able to provide that goes to the point that the commissioner is interested in. I talk there about having parameters worked out in advance. It comes back to that point I said before about consistency and having a plan, having a strategy of how you get from facts and what you need to hopefully a decision on the part of the commissioner that you should receive an uplift on a package overall. Knowing that in advance, one, it helps you focus your evidence and your request, but also it helps in negotiation. That I have seen it done quite effectively. A provider saying to a commissioner, no, we said what we needed. This isn't a commercial negotiation where we say, oh, we'll accept half. We've given you all of the material that you need. We've given you everything demonstrated why we need that uplift. We're not now willing to get into a horse trade. We're interested in you justifying why that level of uplift isn't needed. And I've seen that be quite effective, but it's dependent on you having that supporting body of material, that carefully worked through rationale for why you need the uplift that you're requesting. So before, if it doesn't have a price review, ask. And in terms of timing and opportunities for this, take it all the way back to the contract and look at it's when things change. It's on the anniversary of the contract. It's in advance of when your commissioner sorts its budget and its accounts for the year going forward. It is more or less at any opportune moment where you are able to say, now is a good time for pricing to be reviewed, either on this particular case or across the board. And the earlier that you can work out when those dates might be, the more preparation you've got the opportunity to do in advance. And so the one around budget setting, for example, if you write to a local authority a week before it's publishing its accounts and finalising its budget, probably don't have time to engage with you. If it's 6 months before, then you've just got more opportunity and more time for them to listen to you, potentially be convinced, and then make allowance for it. Said on the slide there, ultimately you're looking for a decision, and it can be a decision to carry out a review, or not to carry out a review, because then if they commit to carrying out a review, at the very least, the door is open, and it is open to the kinds of challenges I've talked about before around rationality, taking into account relevant material. But if they decide not to review pricing, particularly if they decide not to review pricing across number of providers, whole area, then there's potentially grounds for legal challenge, and that would ultimately lead off in the direction of judicial review around the rationality of refusing to consider price increases, and then getting into the territory of looking at the sustainability of the local marketplace, public sector equality duty, impact on residents, potentially an area where working closely with residents, families of residents, is worth considering. But getting a definite decision one way or the other from your commissioner starts the clock ticking for when you might then be in a position to bring a legal challenge, and it also crystallises the scope for that challenge. And I've said at the bottom, plan B. What are you going to do if there's not a price increase available in the near future at all at the level that you need it to be? That having that plan B, because it informs your strategy and it informs potentially some of the points that you can make in discussions with your commissioner. Because if your plan B is that you're not going to be able to continue to deliver services after, say, 12 months, then, and you're committed to that, you're content with that, you know what you're going to do, then the clock is ticking on the commissioner finding a solution that people can live with. But if you don't have the plan B, either somebody will at some stage raise the possibility of you stopping to deliver, or at which point you'll be dealing with it unexpectedly and potentially dealing with the commissioner having concerns about viability, stability, or it might come across as a bit of an empty threat, and that is very, very common. Do see a lot of providers say, we will not be able to continue to deliver services, and then continuing to deliver services. So having the plan B and having the parameters for when you will move to that plan B helps you come across more convincingly and helps you plan as well. So in terms of actually challenging decisions on funding assessments here, exactly which route it's going to be will depend on whether it's being done as part of design of a procurement process, whether it's being done under your particular contract or across all contracts on a particular framework, or whether it is an in-contract price review that you're asking the commissioner to proceed with, or it's a wider cost of care exercise. Most important thing, get it in writing. Ask for underlying decision-making documents, consider freedom of information requests. A surprising amount of public body decision-making is semi-public in the sense of being able to find it in minutes, request copies via freedom of information. It's worth talking to other providers as well if it is something that affects everybody, because different people may know different things, different information may have been shared. And ultimately, what you are looking to do is to work through the basis on which your commissioner has taken the decision, pick up errors if you can, but more often it's pick up what they didn't take into consideration or what they didn't give any weight to. And I just tie that back to your strategy that you had, talked about it a moment ago. Work out what you need and why, and what, that's the basis of your request. That's also the framework potentially for challenging the decision that the local authority has made. You've got the tools in there to say, well, there have been these increases in cost. Local authority has not considered those at all. This is an irrational decision because there's been a failure to consider a highly material consideration that it was aware of. And here is the material that we will rely on in order to demonstrate that. So on all of this, having a plan and having your effectively negotiation strategy and the basis of your challenge, it's all quite heavily interlinked. And what you're doing there as well is giving potentially the material that your commissioner needs in order to change its mind. It does happen. And you're giving people the evidence that they can rely on when it comes to taking your decisions. Question there in terms of what's highly material. It's going to be case by case. Inflation, absolutely. Changes in national minimum wage, other employment changes, or potentially impact, but also things that the Commissioner might have committed to. So real living wage, London living wage, keeping an eye on what the Commissioner is actually saying in public about the sector and what it expects of providers, it can give you ammunition. And indeed, anything else that you are able to share about your local marketplace, then you're in that position of going, well, we've had 3 providers leave the sector. For example, in this area, we are running short on providers. This is a vulnerable sector. That doesn't seem to have been taken into consideration. As I say, case by case. So strategies here, again, all of this is practical. Very little of this is legal. It's having a plan, sticking to that plan, working out where you will go, and working out what the basis of your request to your commissioner is. Is it that only some of the placements that you have are non-viable? Is it that you just have a lot of very similar placements and you need an overall uplift? Is it that you're going to have to start being selective with which placements you accept, which ones you continue? Is it that you're going to have to start looking at exiting the publicly funded care sector? Or is it ultimately viability of the business? That last one is high stakes if it is raised. There are hardship funds, but it would not be the first time that a provider has said, we're likely to go bust very soon, and that becomes a massive safeguarding concern for the local authority. And all of a sudden you are having a very different kind of conversation to the one perhaps you anticipated you would have when somebody said flippantly in a meeting, we're going to go bust. So have the plan, stick to it, and have that strategy. In terms of actual legal challenges, and I don't want to spend very long on this because this is where we hope that nobody actually ends up, it does depend what the basis of your challenge is. So procurement, it's generally through the courts. There's the independent patient choice and procurement panel if it's healthcare services. As I said before, very, very short timescales indeed. So you have to act, you have to get legal advice in terms of your position early doors if it's in the context of a live procurement. Contractual dispute resolution processes, and I'll come on to them in a second, but ultimately through the courts. There's normally more time, but check what your contract says. And public law, so anything that's about decision making by the public body that's not decision making on a contract, on a procurement, so cost of care exercises, consideration of out of contract price reviews, consideration of whether to have wider review or not. Again, strict time limits, 3 months maximum from the point of a decision, but sometimes significantly less than that. Again, get legal advice early doors if you are potentially looking at public law challenge to a decision. Because as with any case, if you leave it too late, it doesn't matter how good the case was. You can be completely right and still not able to take it forward if you've missed the deadline. I mentioned there about contractual dispute resolution processes, and this is part of understanding what is in the contract that you've got. More and more of them will have these. They're often mandatory. You often have to do them. They can be very helpful, and going through that process can actually be better for maintaining the working relationship with your commissioner than a legal challenge, because it gives people the framework that they know that they're operating in. It can get you in front of senior people actually quite quickly. So NHS standard contracts often have 15 operational day sort of timescales between meeting at first level, meeting at second level, meeting at top level, which is director level. You can potentially get in front of chief executive, FD, relatively quickly. And it's something that you can insist on if there's a contractual dispute. If there's a mandatory dispute resolution process, your commissioner needs to meet with you. It's cheaper than legal proceedings generally, and it is just getting the door open to negotiation. So something to look at in terms of your individual contracts, potentially something to take advice on, but don't forget them. Don't overlook them because they can be helpful. And then just final slide you'll be glad to hear. So in terms of cost of care exercises and wider market reviews, just obvious practical steps. Engage. Take part in them. Give commissioners the information that they're asking for. Drown them in information. All of everything that you can bring to bear on influencing the outcome is worth throwing in. It might be disregarded, might not be given very much weight, but if it's not in there, it won't be at all. If you think there's a problem with what's being asked, say so at the start, before they spend 6 months doing it. Put early doors if you think that the scope of the inquiry just isn't right, worth picking at that point up. It can be changed. Work with your local care association, and look with likes of Care England, and you've got the expertise. Commissioners don't necessarily have the expertise in terms of what the impact of what they are proposing. So feed it in. Ultimately, you challenge cost of care exercise through judicial review, potentially through care association working together, but it's not straightforward. Ultimately, what you want to try and do is to feed in to that process as much as you can. So I've rattled through quite a lot of information there about quite a lot of different situations. It's all been, as I say, focusing on what you can do as practically as possible. More than happy pick up questions. I've been picking up some of the ones from the chat as we've been going through where they've been relevant, but I'm sure there's more.
Thank you very much. That's amazing. You covered a huge amount of ground there, so I'll let you grab a sip of water. Delivering service out of the contract, does that mean we live on implied terms? What does that mean in reality? I think we've been talking, I think Angela made the point as well earlier that you responded to around the iSupers, the individual placement service user agreements, coming in after contracts. There's some really bad behaviour and bad practice that we see, but it's because of operational challenges. Sometimes the paperwork follows a very challenging issue to get someone placed quite quickly, but it doesn't mean that we should be hindered contractually as a result of it. I think Mary made some great points there around, a barrister had said that the risks of signing contracts that contain clauses that you haven't reviewed is absolutely commercial suicide at points. But we understand that pressured environment. I think one of the other issues is around, you talked about handing back and terminating contracts, and that's an ultimate ending, and it's not something that any of us want to do, but actually knowing you're out, knowing at what point you have to do that is very, very important. It shouldn't be used as a threat on local authorities, but you absolutely must know as a provider, when is the right time to walk away, and when does it become a safeguarding issue. I'll ask you to take those slides down now, actually, if that's okay, Sam. I'll invite people to come back in and ask some questions in a moment. I think the cross-subsidisation issue is very, very important as well. We see that a huge amount within care. It has been sort of legitimised in many cases, and it's very helpful when you do talk about the legal side. Is a lot of local authorities will look at a business and its viability as opposed to at resident level. I know Gurpreet's put some comments in the chat about that, and I know it was one of my frustrations when I was negotiating with local authorities, and when our resident profiles change. You might have been okay to cross-subsidise at one point, but after a period of time, as profiles increase, it can be really, really challenging. I think commissioners needing more information to make decisions is really important. It's why we always advocate for starting that process 6 months prior to the inflationary window of April. So we're sort of saying August, September, you need to be getting those letters and the profiles and the cost of care constructed and get those into care providers. That's the advice we've always given. Give plenty of time and engage on it, and ask to engage and offer that to support to the commissioners. And having that plan B, when you can't continue, knowing what you're going to do and having a plan for it is really important. I think, the procurement process, the contractual process through the courts, the judicial review process for public law issues and decisions. We don't want to get into that situation. We know that takes a long time. It's cumbersome. Judicial reviews are just getting people to retake decisions. They're not the most effective way of using resources. So that conversation, and I think if I'm right here, Sam, I think the courts, if you do go down the route, they tend to favour those that have tried alternative to dispute resolution as a prior to going straight to legal, I believe.
Indeed. So there is a very strong encouragement from the courts at all levels on all disputes to consider alternative dispute resolution. It can be ordered, and the courts have the power to insist that the parties sit down together and try and resolve matters. Often, the court won't necessarily find out exactly what's gone on, how there's been attempts, but often will be encouraged by the fact that the parties have considered it. And even if it's not completely successful, the statistics on mediation are, I think, in the region of 80-odd% of cases settle at or shortly after mediation. It does work. And you might, if nothing else, have narrowed the issues and worked out what the negotiating parameters are. and you can then potentially get agreement shortly afterwards.
I've got quite a few questions to get through, but Julie has just put her hand up, and Julie did put in a question about dispute resolution process. Julie, is that the question we'd like to ask?
It is, yes. It's just that obviously I work for Hesley Group, so we work with approximately about 120 ICBs and local authorities, and I manage all of our price reviews each year. But we continually have to kick back to the authorities about, we don't let anybody into our services without a signed contract in place. I know about contracts, and I know what kind of clauses to look at in the contract. We always make sure that there's a dispute resolution process that we can follow if we don't agree with it. But then what I'm finding at the moment is a lot of the local authorities are not wanting to engage in the dispute resolution side. So they're telling us this is the fee uplift, and basically that's our decision, and there's no pushback on that because that's the only budgetary envelope that we've got, and they don't want to engage in dispute resolution. Is that allowed, or can we be pushing back on that?
So if the contracts that you have are contracts that provide for price reviews in the contract itself, that is it is a contractual step that has to be taken by local authority, then from my side, I would certainly look at that and go, if there's a mandatory dispute resolution process, there you are raising a dispute, that is, that you think that the assessment on price is incorrect. I would have thought that that's comfortably within the scope of the dispute resolution process. Ultimately there, if there's a refusal to engage in contractual dispute resolution process, can be enforced through the courts. Party can be required to participate in it. To caveat heavily, if it's not a contractual price review, that is unlikely to apply. So if it is something that local authority is doing voluntarily or just as part of its wider policy, it's likely to say that's not under the contract, so the dispute resolution process isn't engaged. But I would have thought if it's a contractual contractual price review, and there is a dispute as to that price review, and it might be talked earlier about Braganza duties. You think they've been irrational, you think they've taken into account irrelevant considerations. If you can articulate that, I would certainly say that falls in the scope of the dispute resolution process.
Okay,
and that's something to push on.
Thank you. I think Gurpreet raised a point around viability at an individual level rather than business level. I think we've kind of covered that. I'm going to move on to Ashley's question. It's a statement as opposed to a question, but I think it's a question here. We have a mixture of residents funded by the ICB and the local authority. We hold historic overarching contracts with the ICB, but despite previous requests, the local authority advised that no equivalent overarching contract is available. For many placements, we only have historic iSupers, which contain limited detail and often only specific and specify the story of the weekly fee. So what is their contractual position? Where's the contract there?
So contract doesn't have to be in writing. It can be verbal and it can be by conduct. And so what I would need to do in order to work out reliably what your contract terms are there with adult social care, with local authority, is sit down and work out what has happened in practice over the length of this, what's changed, and try and establish as far as possible what key terms there are. It's likely to be a pretty minimal contract, that's the thing. So it will have things like price, it may have an implied term around notice to terminate, but it wouldn't necessarily imply a lot of the contract terms that you might expect to see in a written contract. The courts will likely determine there's a contract in place, but they will only determine what they can from the course of conduct between the parties. This ultimately comes back to this point about trying to get contracts in place in advance, because picking this kind of situation up years down the line really often is a nightmare. And it sounds like it could be a bit of a nightmare from the commissioner side in the event that there's ever a dispute. But I would certainly be looking at that situation and going, okay, this is a mess, both you and the commissioner. What is going to be done in order to rectify that? And we come back to that question about leverage and about what your overall strategy will be if these are individual placements that you're potentially having issues with, or overall it's not viable. But this is one, I'm afraid, Ashley, where I'm going to say specific legal advice in terms of establishing what the contract terms might be, because it's going to depend so much on your own circumstances.
Thank you And I think the implied terms is interesting. So, you know, we know that a contract can be formed with offer acceptance and consideration, but in terms of if the term isn't expressly made, as in termination or fee or whatever it happens to be, then it does become implied, and there's some ambiguity over what are implied terms, and that's really for the legal people to try and resolve what those issues are. Is that correct, Sam?
Exactly, yes. And there are very often multiple reasonable views on what the implied terms would be. It's worth people having that. Always risky, particularly around things like notice periods, where a reasonable notice period could be anywhere from 6 months to 3 years.
And in Ashley's situation, would a rational thing be to actually write the ICB in the local and say, what terms and conditions are we working to here? Please send me a copy.
From the sound of things, that's exactly what Ashley's done for the local authority, and which is why I'm saying effectively treating this as a mess that needs a solution. If the local authority is truly unable to point to what its overarching contract is, and just trying to avoid it drifting, keeping this on people's radar, keeping this as a constant issue, and looking at what your plan B will be. Because from the local authority's perspective, it might be perfectly happy just ignoring this for the next 5 years, but that leaves you with the uncertainty.
I've got a lot of questions come through now, so I'm going to go a bit quicker. So Mary made a comment. Mary has a not yet signed contract. Overarching contract suggests providers must offer unlimited liability for council's costs, especially to the council's costs at moving service users if need be. Makes going bust seem very expensive and risky. What are your thoughts on that in terms of reasonableness? So
commercial discussion on what contract terms are to be offered. I'm afraid reasonableness tends to go out of the window when it's between two commercial organisations. The limits on what terms are so unfair that they will not be incorporated into contracts in this context are pretty minimal. I know the kind of clause that Mary's referring to in the context of either provider breaches or provider failure where the local authority needs to intervene. It's a matter for negotiation. I have to say I've seen them quite a lot in contracts that people have signed up to. Something to look at potentially is insurance. What cover can you get in place in the event of business interruption, in the event of potential disputes? Insurance, I'd say as well in respect of legal support and costs, actually is something for providers to think about. But when you're faced with those kinds of clauses, when there is a potential future liability that you need to mitigate, looking at insurance is often a worthwhile cause. Seeing what you can do in terms of negotiations, seeing what you can do in terms of negotiating a cap.
But also not taking on board an uncapped liability. I know in my prior role, that was one of the first things we would put back on, and we would look to limit it to what was reasonable at fault and for the right reasons. Ada has said that our authorities and ICBs mandatorily are required to send statutory annual inflation uplift letters advising providers of changes to rates. I think I'm going to expand on this slightly, is that I think when the decision is made is also a very important point at which the local authority determines when the fee decision is made. When they communicate it is often at a separate time, but legally there's an issue there. Would you like to just talk about that briefly, Sam?
I'm not sure that there is an obligation, so a general public law obligation on a authority to set out at a particular time. If it is changing a term of the contract's quite likely to say how that's to be done, what needs to be done. It might need to be signed by both parties, for example. Ultimately, if they want it to be implemented, I'd expect them to be communicating. I'm not aware of any obligation that they would have to do so particular timescale. It's going to depend on your particular arrangements with that commissioner, I think. It is a point I'm happy to take away and have a look at, though.
Thank you very much. And if there's no provision in the contract for annual uplifts, then you need to try and negotiate that in before you accept the resident or at the point at which you sign a contract. And Julie has put a helpful note in there, is have your own contract ready for when the local authority has to come back saying that they don't have one in place in time for admission. I think that's where you get into a slight battle of the forms situation. The largers usually win over the smallers, but absolutely always push your terms and conditions forward and use those as a very helpful position to kind of defend your position, I think is sensible advice. I've got some other questions here that I want to come on to, if that's okay. This was asked prior registration. So financial pressures within local authorities are well understood. I think we all need to acknowledge those, but funding constraints should not result in providers being expected to operate in ways that risk non-compliance with employment law or undermine fair work conditions. How can we effectively challenge this? Nothing has worked for us so far. Great question.
Certainly. So a few key points to just pick up on that. I've talked quite a bit as been going through in terms of just modelling what your situation is. What are the actual cost pressures? What is the impact that that is having on your business? And in the context, particularly of domiciliary care, care in people's homes where there's travel, staffing challenges there as well, it is perhaps that modelling of what is being expected of you, what is being asked, and how does that fit with commissioners' policy statements, which may include things like we expect providers to pay for travel time, or may expect providers to pay real living wage, or may expect providers to have regard to this, and just looking at what it is that they're saying as against how the contract that they're proposing actually operates in practice, and having that ability to go, it simply is not viable to meet your expectations on suppliers without treating staff unfairly, without risking non-compliances. It's also worth looking at the public sector equality duty there in terms of just the impact that this might have on service users, particularly vulnerable disabled service users in particular, and potentially even looking at how it will impact on staff, and looking at the cohorts of people who are likely to be staff and who are likely to be affected by commissioning decisions that essentially mean that they are very much on the edge of as you've said, employment law or fair working conditions, being in a position to push back on that. This is also an area where working with service users, families, is potentially worth serious consideration, because they are likely to bring a different angle of attack in terms of ensuring that family members are fully supported, and they can be putting pressure on from a different angle. And fundamentally, it comes back to the practical points that we've touched on repeatedly, trying to get yourself in a position where at the very least you can be a bit selective in terms of which services you're being asked to pick up, how that's going to work for you, and being prepared to walk away if essentially what you're being presented with is a model that you simply cannot make work. And touched on before, getting this nailed down at the start rather than halfway through the contract, particularly critical when talking in those kinds of terms.
Not to go down a bit of a rabbit hole here, but in terms of exercising or reinforcing or pointing to the Local Authorities Care Act duties towards a control, meeting assessed needs and what have you, is that a helpful point of leverage at that point?
So absolutely, and it comes down to, is the pressure here being put onto you and onto staff? Is it being put onto the model of care that is being proposed for particular service users? Is it going to impact on everybody? And in addition to the character responsibilities to the individual, and some of those are points that can be put forward very effectively indeed by family members, it's worth also looking at the Care Act responsibilities in the context of the local marketplace for care, and ensuring that there are a range of providers and a range of high quality providers, and it is possible for service users to exercise a degree of selection as to the providers that they get. And a sort of race to the bottom, particularly, as I say, in that kind of domiciliary care model, runs the risk that you end up with limited providers, and those providers all having a very similar service model.
Fantastic. And I think that always have a minimum of a choice of one. I always found that one a bit confusing. The next question, I would like to know what pushback can be used to prevent an inclusion of the efficiency requirements being used to reduce fees, and what are the effective arguments when challenging the use of CPI to include that when you've got national insurance increases. So I think for me is that we see the ICBs offer the efficiency factor annually. Some of them choose to apply that factor, some local authorities choose to do it, but yeah, CPI and those efficiency factors, how do we challenge those despite all of our costs continually rising?
Yeah, so in terms of the efficiency factor, how I'm understanding this is in the context of a term effectively expecting you to achieve efficiencies over the life of the contract and effectively reduce the costs to you of delivering the service. And so we end up in this position that you've almost got a baked in a price decrease kind of tool, or at the very least a percentile that you need to get past in order to justify price increases. If it's start of the contract and you're negotiating, it's an area to push back on, or at least an area to try and get clarified. If you're working with a contract that's already got it baked in, this is one of these ones where it is absolutely critical to be able to demonstrate that you have achieved efficiencies as far as possible, and that has already been taken into account. So if you can advance an argument on the basis effectively that you have taken it into consideration, and it has, for example, been entirely wiped out by one factor that is increasing your costs, then you're in perhaps a better position to put forward. And there are these two other factors which have increased our costs significantly. And so having a multifaceted argument here, effectively, there are all of these different factors leading to cost increases. We're aware of our contractual expectation on efficiencies. We've dealt with them, and that's been wiped out by some change. And then there have been some other changes that have pushed our costs up. So it's been taken into account, but still services ending up not viable. It's a tricky position to end up in, but also this is the kind of point where conceivably an individual level with your commissioner, even if there's not, for example, willing to look at a price increase on the terms that you're looking for, agreeing waiver of those kinds of clauses, agreeing that won't be taken into account on any particular occasion, there's potentially scope for negotiation at the margins. And in terms of the use of CPI, more or less just as a blanket, we're going to increase by CPI, and that takes account of national insurance, etc. This is potentially a point where working across multiple providers to look at a bit of specialist modelling and looking at how those how national insurance increase impacts on your sector specifically. And so being able to go over here, CPI covers a range of sectors, range of costs. The care sector particularly influenced by cost of staffing, it's going to be disproportionately have an impact here. Simply using that blanket measure to take account of that national insurance doesn't take account of the fact that if you're a provider with relatively few staff, you're going to have completely different impact on them than it would on you.
Well, I think really it's having that evidence and the case study and the cost of care and explaining what your costs are. I'm conscious we've got 3 minutes. There's one question I do want to ask here because it's just popped in actually. Often many social workers seek to reduce the fee after the client's been placed on the threat to move them somewhere else cheaper. What would you advise in that situation? That happens a lot. We hear about this behaviour a lot with providers. What are your thoughts on that, just briefly before we wrap up?
So sorry, just making sure I understand. So when talk about client being placed on threat, are you just able to expand?
A client is placed and a fee is agreed, and then a social worker tries to reduce the fee afterwards, retrospectively after placement, saying, well, if you don't take the reduced fee, we'll move them. So
going to say it again, come back to the getting the contract in place and understanding what the termination provisions on the authority side are, because if that is in 6 months' time, we might move them. That might be somewhat different to if you've got they can move them on a month's notice. Effectively, what the social worker is looking at doing is disrupting an individual's package of care in order to achieve financial saving. And that is the kind of point where potentially would be looking at working with resident, looking with client, working with family to push back on that, because that does strike me as an improper negotiating strategy that runs the risk of detriment to the individual. It's going to come down to the contract, and it almost would be an area where I would think the pressure comes better from family, potentially insisting that they remain there, raising all manner of concerns about what's being proposed and the impact on the care, than it might be coming from you. But going to turn on the contract.
I'm going to have to draw us to a close there, Sam. Just a huge thank you. What I will say to people before they sign off, there's quite a lot of questions we haven't been able to answer today. If you think another session would be helpful where we can put those questions to Sam or one of his colleagues and we can talk about this further, please just put a note in the chat if you think that would be helpful, and I will discuss with Sam if enough people want it to try and schedule that session. But I just want to say a big thank you for such a clear session. We've only skimmed the surface of what is an incredibly important session. Thank you to everyone who's joined today. We will share the recording, the slides, Sam's contact details if you want to reach out to him directly. Thank you for giving up your time. Thank you, Sam, for giving up your time. I'll ask you to stay on if that's okay, Sam. But it would be great to see you all again very, very soon. And I think looking at what's going in the chat, we probably do want to organise another session. But thank you all very much for your time today. Thank you.